You want to know the secret of surviving air travel? After you get where you're going, you take off your shoes and socks. Then you walk around on the rug barefoot and make fists with your toes. Well, that terrific and consequential advice given to John McClane at the beginning of Die Hard sets the tone for today's episode. We're going to talk about surviving air travel above national parks, free from CEQA rules, thanks to the DC Circuit. And we're going to talk about surviving sovereign immunity with the Commonwealth of Virginia in the Fourth Circuit. All that and more on today's episode, which is most definitely a Christmas episode of Short Circuit, your podcast of the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, December 11th, 2024, but it will go out right around Christmas 2024, and so, hence, the garments, as old Scrooge would say. Now, this is a rare episode where YouTube viewers will get a little bit more out of it than audio listeners. So if you're an audio listener, great, listen to the episode. But I encourage you to go back and look at a little bit of the YouTube later, because we have dressed appropriately for the Christmas season. So I'm going to introduce our two guests. We have two powerhouse mega guests today that I'm very excited to share with you. So first of all, I'm going to introduce you to both of these gentlemen have been on the show before, but I'm very happy to have them back. It's been a little while. One is Dan Knepper. He is IJ's CFO and general counsel, and he has joined us today with a garment that you may need to move a little bit so the audience can get the full effect, Dan. There we are. So Dan is wearing a sweater, Christmas sweater with a dinosaur. So Dan, tell me how you acquired this sweater and you know what your general thoughts are about it.
I really wanted a Christmas sweater with a dinosaur on it. And I found one that had a T-Rex and they have short arms, and the T-Rex is wearing a Christmas sweater, but the sleeves are too long for it. And I said, man, that is the right sweater for me.
So they don't make Christmas sweaters for T-Rex appropriate arms?
Apparently not a huge market.
Oh, man. Okay, well, that's a great sweater. Next, we have Bert Gall. He is our managing vice president and senior attorney, usually in our Austin, Texas office, but he is specially here just for this show today in our HQ in Arlington, Virginia. And Bert, you have something that may have a little bit to do with the opening I gave.
Sure, yeah. I mean, the best movie ever made is Die Hard, and it also happens to be the best Christmas movie ever made. So, yes, my sweater commemorates the Nakatomi Plaza Christmas party of 1988. And like John McClane, I'm glad to come out and have a few laughs. At least that's what you promised.
And do you take your shoes and socks off after you fly?
Oh, absolutely. Although, you know, I did learn from Die Hard that you should keep them nearby just in case, you know, Hans Gruber comes by. So,
yeah, good point.
Yeah.
I got to keep that in mind. Well, I myself have a Christmas sweater my family gave me many years ago. It has Santa Claus and some cats pulling a sleigh, and that the cats are in 3D, which is kind of, which means I can never wash this. So I only wear it on Christmas. And actually, even then it's getting a little old, so I don't know if I'm going to wear it this year, but I've worn it today, so we can get that out of the way. So this got me thinking. I think it was Bert's suggestion to wear Christmas sweaters was absolutely awesome idea. Like, Christmas sweaters, where does this thing come from? Like, when I was a kid, I don't remember Christmas sweaters being a thing. I'm sure they've been around since sweaters have been around, but in some way, right? But as like a kind of hipster, like ironic thing. And what I came to mind, and maybe you gentlemen would think the same thing, is Bridget Jones's Diary, the movie. Renee Zellweger, when she runs into Colin Firth at the beginning at the turkey curry buffet, he turns around and he's wearing this like ridiculous like reindeer sweater. And that then kind of, it seems like, took off the modern day Christmas sweater phenomenon. I looked it up. I did some brief research on the internet, and probably people who think like me wrote the same thing. So I don't know if that's actually true, if there's been some scientific investigation as Christmas sweaters before 2001, which I think was when the movie came out. So then I thought, oh, well, I've read Bridget Jones's Diary book, the book, which came out in 96. So I'll go back and look at that. And you know what? In the book, it's not a Christmas sweater. So it's kind of the same whole thing. There's a turkey curry buffet, but then it says this. He turned round, revealing that what had seemed from the back like a harmless navy sweater was actually a V-necked diamond pattern in shades of yellow and blue, as favored by the more elderly of the nation's sports reporters. So it was an old man sweater, like maybe kind of a Cosby Show sweater, we used to say, with like those triangles, but it wasn't a Christmas sweater. So they got that innovation for the movie, and then the rest is history. And
wow,
Bert, the rest was history. It is a scandal. The rest was history, and it was a scandal when Virginia was readmitted to the Union. And so I want you to tell us about this Fourth Circuit case that it's not really about it at this point, but it has in the background this whole Civil War, state sovereignty, getting into the Union. What's all that about?
Well, what's the saying that the past isn't dead, it's not even past? Well, that applies to this case coming out of the Fourth Circuit, where the Virginia Readmission Act of 1870 makes an appearance because I think some very clever and good lawyering on behalf of some felons, people who were disenfranchised voters under Virginia Constitution because they had felony drug possession and one of them had some other felonies, and they sued to have their voting rights restored. And they said, yes, the Virginia Constitution clearly disenfranchises us. However, in doing so, it violates the Virginia Readmission Act of 1870. And that act, which basically allowed Virginia's representatives to come back into Congress, says that citizens of the Virginia Constitution may not disenfranchise any citizens, and it may not be amended to disenfranchise any citizens unless they had been convicted of crimes at common law that basically existed at the time and had received due process and equal treatment as all other citizens. Now, you can imagine, given the historical circumstances, that this was a big deal, given the fact that I'm sure that the Virginia legislature was probably still very keen on enforcing segregation in the aftermath of slavery, and I'm sure that's probably where this provision comes from. But I guess maybe nobody this act had probably been lost to history until this case, and it leads to an interesting discussion by the Fourth Circuit of sovereign immunity and ex parte Young. As our astute listeners know, ex parte Young is a way that you can penetrate state sovereignty when it comes to enforcing federal law. If a state or state officers are violating federal law, ex parte Young, you can sue state officials in their official capacity to get prospective relief to stop them from violating federal law. So the 11th Amendment may prevent you from suing these folks to get damages or something from the state fisc, but you can sue to enforce federal law, prevent state actors from violating that. So, as the Fourth Circuit says, this seems like a pretty simple case. Here come these folks. They are claiming that the Virginia Constitution and their disenfranchisement under it violates a federal law from long ago, and they're asking for prospective relief to enforce it. And ex parte Young should apply. But Virginia has different ideas, and so you have a long discussion of ex parte Young, where Virginia takes the tactic of saying, well, ex parte Young only applies in very limited circumstances. It only applies when you are trying to enforce specific federal rights, or when you want to stop the state from filing a lawsuit to enforce a law that violates federal law. And neither of those circumstances apply here because the felons don't have any. They're not asserting any rights under federal law. And the Fourth Circuit says, they're trying to basically make the state comply with federal law. That's good enough. Like, what the heck are you talking about, Virginia? And so they swat that argument away, pretty easily. And when I am reminded of the Ann Landers column, I believe, yes, Virginia, there is a Santa Claus. And I think I can imagine it's not in the decision, but yes, Virginia, there is an ex parte Young, and no, Virginia, your exceptions don't really work that you're proposing here to it. Virginia also argues, makes some other arguments, including some that they attempt to make on the merits. They also, point out that it is possible for Congress to act in such a way to prescribe the courts from enforcing certain federal laws. And the Supreme Court has indeed, recognized this in a circumstance in which Congress has passed a law, and the law provides a clear remedy, a remedy mechanism, and that mechanism is outside the federal courts, and where Congress, the statute itself, doesn't really provide any judicially enforceable standards. It's very, very broad. But those circumstances just simply don't apply here because, there is no specific remedy, explicit remedy, here under the Readmission Act. Virginia argues that there's an implied remedy of ejecting all of its representatives from Congress, but that's certainly not an explicit remedy here. And then Virginia says, well, it's going to be really hard to figure out what about these felonies at common law. That's going to be very difficult to administer. And the Fourth Circuit is like, no, we can figure that out. I mean, that's the kind of things that courts do. Virginia also says, well, look, this isn't actually an attempt to enforce federal law. It's not an attempt to enforce the Readmission Act. It is instead an attempt to enforce the Virginia Constitution because in order to interpret the Admission Act, you've got to reference the Virginia Constitution. You have to reference Virginia common law. The Fourth Circuit brushes that off as well and says, look, just because you have to reference and look to state common law and state history doesn't mean that you are not enforcing or looking at a federal provision. Indeed, when you're looking at the Due Process Clause, for example, or what is defined as property, right? Courts are often looking at what states have said in state history. And also probably not a convincing argument by Virginia when you have a Supreme Court that is, emphasized the importance of history, and tradition. You basically don't want to, basically Virginia's trying to say we don't want to do our homework, on this. And so the plaintiffs prevail, and they will get their day in court to argue that they should not be disenfranchised. Now, on the merits, we will see, right, that this isn't a case about litigating whether their crimes are ones that Virginia could actually disenfranchise them for, but they will get their day in court. They will get a chance to make, these arguments. And I just found this case really interesting because, ex parte Young is very settled law, very, very, very settled law. And a bit disturbing that Virginia tried to kind of carve out exceptions to it, make up exceptions to it, and basically try to, say federal courts, butt out. So I found that actually it's a very interesting case, but I think a bit disturbing that Virginia or the attorneys for Virginia were willing to make those arguments, or maybe they missed Fed courts in law school. I don't know which one it was, but a bit disturbing and a good case for for history buffs because the law, ancient laws are still law. They're not dead, and good lawyering, creative lawyering, I think employed by plaintiffs' counsel here, has brought the Readmission Act to the forefront.
So I want to ask you, Bert, about the Readmission Act stuff in a moment. But on your point about how ex parte Young, pretty standard legal stuff that comes up a lot in these cases, it seems like maybe that just the novelty of this Readmission Act request, instead of it being a standard, like First Amendment, Fourth Amendment type of claim, gave them a thought that they'd have a chance. There's a chance here to get this case thrown out, which I gotta say, probably in some circuits, it very well might work, just because of its novelty. Do you think that's what was going on there?
Yeah, I think it's possible. I thought you were about to make a reference to Dumb and Dumber. Like, are you saying there's a chance? But it's not really a holiday movie, right? But that's okay. I'll allow it. I do think that what was going on. And look, the plaintiffs had brought other claims as well that had been dismissed. So maybe the fact that this is like the lone surviving claim that you don't get reliance on federal statutes from the 19th century every day, probably led them to think that they could take this particular tactic here.
So we don't know much about this Readmission Act argument from the case, and it probably hasn't even been developed that much in the briefing in the case yet, but we may know more about that soon. But from what I can tell, the argument is that the the Reconstruction Constitution that was approved by Congress was a certain way where back then people like this would have been able to vote. The Readmission Act says, okay, if you ever change that Constitution to have more barriers than just common law felony, whatever that is, but it seems like it doesn't apply to what these guys have done, then you can't do that. And then, as we know, after Reconstruction laws were never enforced.
Right.
And so all these states changed all their constitutions in many ways, and that was never enforced. And now they're coming back and saying, well, we want to actually enforce this act from back then. So that's one angle of it. Another angle I see, so given your background, I'm a little curious about this. There's some history, right, of states being admitted to the Union with certain mandates from Congress, and then the state will be admitted, but then at that point, they're on par with any other state, including, states from the original 13. And then the argument is that at that point, there's comity between states and they can do whatever they want. And indeed, many states have done, so for one example, I think it was Arizona was admitted saying, you can't have this in your constitution. I can't remember what it was, but Arizonans right now are probably screaming into their, devices to correct me. But it's that you can't do this. And so Arizona got admitted to the Union, and a few months later, they had a referendum and did it anyway. It might have been how they choose judges or something like that. And that's also true, I think, with Blaine amendments, right? That we have warred against at IJ, that many states were admitted in the late 19th century into the Union on the mandate that they have a Blaine amendment, something like it. And so in theory, right, they can't get rid of their Blaine amendments, but it seems pretty clear everyone would think they can, because just like any state can change its constitution. So is that, do you think that's going to come up in this case? All this kind of competing values about the federal law versus state sovereignty, but not in a sovereign immunity context, like in another context, or is that maybe making it a little too complicated?
Yeah, the interesting thing about Blaine amendments, including those that Congress required a lot of Western states to include in their state constitutions, is that states didn't get rid of them. Now, like those states, and I think part of it was, right, there was an effort to enact a federal Blaine Amendment that failed. And because there was at the time, a lot of anti-Catholic, anti-immigrant sentiment in the country to prevent direct funding of Catholic schools because, Catholics did not like the idea of sending their kids to, quote, public schools that weren't really public schools like we think of today. They were really more like Protestant light, schools where you would basically be learning Protestantism. And so I think with the popularity of Blaine amendments at the time, I think a lot of states probably didn't protest that much about the inclusion of these Blaine amendments in their state constitution. And certainly, we at IJ have litigated and neutered Blaine amendments as an obstacle to educational choice, pointing out that, these Blaine amendments weren't targeted at educational choice scholarships. They were really more pointed at direct funding of Catholic schools. But that's an interesting point about like whether a state could actually go back and do that. Like in this case, if they did, they would be running up against federal law. I don't know, for example, I guess for each of the individual Blaine states, you'd have to go back and look at their individual readmission acts to see.
Admission act.
Yeah. That's right.
And
admission.
Maybe there's a difference.
No, that's true. Yeah, they're admission acts, and then their
Maybe
readmission acts. And is there a difference between, admission and readmission to the union in terms of like in terms of like the state federal comity, principles that we usually abide by? Because obviously, when it comes to readmission, that comity was basically non-existent. Like you want back on board the union. Here's what you've got to do. So I don't know that it'll come up in this instance. I think maybe Virginia will try to say we can do what we want to do. My prediction is that the litigation in the district court and eventually back up in the Fourth Circuit though will kind of center on an analysis of what are these felonies at common law? And I think it'll be a really interesting question given, readmission acts kind of more generally. I don't know, like how other readmission acts, compare to Virginia's in regards to these kinds of disenfranchisement provisions. But I think the Fourth Circuit will be really kind of interested in the district court too. We'll be interested in kind of digging into that.
Okay. Well, we'll look forward to that, and eventually, when it maybe gets up to the Fourth Circuit, again, we'll try and have it on Short Circuit, and I'm sure we'll cover it in the newsletter. We're also digging into administrative law today. So this was a bit of a sleeper that I didn't see when it came out about a month ago, but Dan has alerted to me, and it seems like reading. So when I read this opinion, I get to section 2, and I read the first paragraph, and it's the closest you can get to a mic drop on the page in an administrative law decision. So Dan, tell us about that. And did you have a similar reaction?
I did. And to play on the theme here, we got the D.C. Circuit Court of Appeal delivering a couple of lumps of coal in this decision. So we're looking at Marin Audubon versus FAA and National Park Service. It was decided November 12th, and at first blush, this seems to be a pretty typical NEPA dispute, right? The agencies made a determination on a program. In this case, the private air tour flights over national parks, and environmental groups sued, saying that the environmental review wasn't sufficient, and threw it to the courts to say if it was or if it wasn't.
And NEPA, Dan, is the National Environmental
Policy Act. And we'll talk about that in a minute. And instead of the court saying the review was sufficient or not sufficient, it also got it said, 50 years of environmental regulation, we're just going to throw it out. Right. And they didn't. Nobody asked them to do it. This is just something the court said. Today's the day to make this happen. So we're going to look at we're going to look at the laws at play here. We're going to look a little bit at the fact background, which included 20 years of inactivity by the agencies. We'll talk about how the court and why the court arrived at where it did, and maybe they got it right, but nobody asked them to do it. And we'll see what we can speculate as to what happens next. So first, the NEPA is the National Environmental Policy Act. It requires agencies to take a hard look at the environmental impacts of major agency actions. So think things like granting permits and programs and the like. NEPA is very much the source of a lot of litigation regarding big infrastructure projects and has earned a reputation as a vehicle, a well-earned reputation as a vehicle by which projects can be delayed. Tons of litigation around it. In fact, just yesterday, the Supreme Court heard arguments in Seven County Infrastructure Coalition versus Eagle County, Colorado, where the issue was whether and to what extent NEPA requires an agency to consider indirect or, in this case, pretty remote effects of a project that is evaluating. So it is a topical. It's very much in the focus right now, and NEPA's regulations, or regulations that the agencies follow, rather when trying to follow NEPA, are Council on Environmental Quality regulations, and that's going to become the focus of this case. The CEQ promulgated regulations at an executive order by Carter that said, hey, all the agencies have to follow these regulations when they evaluate, when they do their NEPA analyses. And it can be a big, lengthy document called an environmental impact statement. It can be a shorter document called an environmental assessment. And in certain instances where an action doesn't normally have a significant impact on the environment, they can categorically exclude it from an environmental review, right? And that's what ended up happening here before the court said, nah, we're just going to get rid of it all. So, the substantive law at issue in this case is the Air Tour Management Act of 2000, and the FAA and National Park Service were directed by Congress to make every effort to establish rules governing such flights within 2 years of the first application of these tours. And this is the act. It was in 2000, and we can fast forward to 2018, and nothing had happened yet, like zero.
I wish I worked there.
Right.
Sounds like good benefits.
There was the D.C. Circuit Court of Appeals had issued a writ of mandamus at the request of environmental groups in 2000, where it detailed some of the history that went on here, and in the FAA and the National Park Service could not agree on certain things like who gets the final say on how loud the planes get to be, right? Those types of things. So, no, it's our call. No, it's our call. And so they ended up not doing very much at all. And in 2000, the D.C. Circuit issued the order that said, you guys got to get your act together and you tell us how things are going, and I'm sure we'll keep an eye on it for you. So, one of the efforts that the agencies made was to combine the four national parks in the Bay Area, and to issue a plan for private air travel in those four parks. And the way that they did it is they said, okay, how many flights happen now? Right. This is roughly what happened. How many flights happen now? There's about 2,500 plus flights that happen per year right now. We'll say, okay, you're allowed to make 2,500 plus flights per year. That's going to be our baseline. And then we're going to put some mitigation in place where you say, it has to be certain types of planes, only certain types of days. You have to avoid certain routes, those types of things. And since that's already happening today, but we're adding this mitigation to it, we're going to categorically exclude this from NEPA review. Right, like this is not likely to have an effect on a negative impact on the environment, and we are permitted to do this by CEQ regulations, which say the baseline's what's happening right now, and since that baseline's 2,500 flights, and we're saying can only fly, all we're going to do is make the environment better, right? And a couple of environmental groups got together and said that doesn't make a lot of sense. right? Like the act actually says like you're allowed to prohibit all flights. The baseline here it should be not what's happening today, right? So courts help us figure this out. Um, and the DC Circuit laid out that background and said, you're thinking, hey, this is a pretty straightforward case. It sounds like maybe the agencies were arbitrary and capricious in this determination, and that's what the court would eventually decide in part 3 of the opinion. But then in part 2 of the opinion, before getting there, the court said about those CEQ regulations. All right, a little bit of history here. NEPA was, I think, 1969. Right? It was one of the first, if not the first, it was one of the first major environmental laws in the country. And NEPA said you have to take a hard look at environmental impacts. And then in part 2, it created the Council on Environmental Quality. Council on Environmental Quality is intended to provide advice to the president. And it uses more words than this, but hey, provide advice, recommendations, perform some studies. Let's make sure the environment's getting taken care of. And as soon as the ink was dry on NEPA, Nixon issued an executive order that said, we're going to ask the CEQ provide guidance to agencies implementing in how they implement NEPA and how they act around it. Because NEPA, a whole lot of litigation ensued. And in 1977, Carter issued a second executive order that said, no, let's codify. Let's make clear what's actually happening here. The CEQ is to issue these regulations, is to issue regulations that agencies have to follow when they are implementing the National Environmental Policy Act as they evaluate what they are doing. Right. So the DC Circuit said, and I have it written down because I wanted to quote the mic drop moment, Anthony. Both sides in this case took for granted CEQ's authority to issue binding NEPA regulations. Although questions about this were raised at oral argument, no party sought leave to file a post-argument brief. That is understandable. Petitioners claim the agencies violated CEQ regulations. The agencies denied the charge and defended by invoking CEQ regulations. Despite the parties' acquiescence in CEQ's regulating authority, we retain the independent power to identify and apply the proper construction of governing law. And that is especially true when the proper construction is that a law does not govern because it is not enforced, it is not legally binding. And it actually says that it is, it says it's ultra virus, right? It says so after going out of its way to toss out 50 years of practice on environmental regulation,
which nobody asked for.
Nobody asked for. The court then really quickly says it's arbitrary. This is silly. The baseline is not. The agencies didn't act properly here. Like they used the wrong baseline. And then they turn to remedy, and they say, one lump of coal isn't enough for these parties. We're going to send a second lump of coal, and they vacate it, right? They instead of remanding it back to the agencies to figure out how to get this right, or maybe they're close, they toss it out altogether. They said there's no way that agencies can know that the result they're going to reach is anything close to what they have now. So we're throwing it all out. Now, why is this even another? Because neither party asked for that either, right? By throwing it out, they return to the flights that exist now with none of the mitigation and none of so it's status quo. Interestingly, it's a per curiam opinion, and it was written by Senior Circuit Judge Randolph, and he added a concurrence to it, where he dug into some legislative history, if you will, about what to do when you find that an agency has not complied with the APA, and he quotes from Justice Marshall's notes, including conversations and drafts that were exchanged between Justice Scalia and Justice Kennedy, I believe, where Justice Scalia mapped out, like, we don't have an option. It says shall, right? We shall throw it out if it does not comply. And Judge Randolph says we're obligated to do it. We have to throw it out. The Chief Judge, Sir Vincent, said that he wrote a dissent where he said, we don't need to do any of this. right? We don't need to reach the CEQ regulations, and we don't need to vacate. Not sure why we're doing it here. It was clearly arbitrary and capricious. We might have stepped, in my view, the court might have stepped out of bounds a little bit, right? And it took the parties about a minute to both file for en banc, right? And they both made the point of saying these issues weren't presented, right? Usually in our adversarial system, we don't like courts of appeals to go out on their own. Because there's a lot of research and things like that. We count on the attorneys and the parties to bring those issues to us. They didn't do that here, and so I'm a little skeptical given that we didn't need to go there to get to the outcome in this case about why we did that now. So I think what was happening here is that we had agencies that hadn't acted for a very long time, and Congress had told them they needed to do that. And then in 2023, we had a Supreme Court decision, I think it was California v. EPA, that said executive orders may not act like statutes, right? It reconfirmed. We'll say it reconfirmed that point. And in 24, we had Loper, which said agencies don't get any deference. And you had the pillars or the basis on which the CEQ regulation stood get knocked out from under it, and pretty right one after another in the last couple of years. And the DC Circuit said it's time. Right, like there is no any basis on which these regulations had to stand as regulations is gone. Right, we're gonna say that we're gonna throw them out, and we'll let the parties continue this fight and en banc and down the line if they want to.
This case reminds me, Dan, of two Latin phrases. One is what you just referenced, I think, carpe diem. Seize the day. This was time. I don't care if no one briefed it. It's time. And then the other one, fiat iudicia. I'm butchering this. Ruat calum, which most people know as let justice be done though the heavens fall. And that was the mic drop. And so now we're left with no CEQ regulations, even though the parties in the case didn't ask for this. And what amazes me is not that happened, because that's kind of in line with agency law these days, administrative law, but that there was no precedent in the DC Circuit that went the other way since 1977. Yeah. It's just been taken for granted. So there's no holding saying that that's the law. That's just flabbergasting.
There has been questions raised, in almost like a law school professorial sense, or they're like, CEQ really do this? Right? Is this really something CEQ can do? And everybody's like, it's the rules we play by, right? Like we need some rules. It's what's out there, but maybe somebody should write a law review article on it, or something along those lines, and we could have a nice philosophical discussion on it. The DC Circuit Court said the time for philosophical discussion is over.
So, Bert, curious of your thoughts about this, especially because you've been involved in cases where courts just do stuff without the parties briefing it, and probably haven't been too happy about that.
Well, courts will, they have their own minds, and here this was clearly something I think that had been on the DC Circuit's radar, for some time. And I think it's okay for courts to do that. I do think it is better when they give the parties a chance to fully brief the issue and fully dig in to it. I think so maybe maybe the DC Circuit should have done that here. They might respond. This panel might respond by saying, well, this is actually an issue that keeps coming up. We don't need any more briefing, on it. There's been enough debate that has fomented on this, and so we're just going to do it. We're going to do it now. But I certainly think, in general, it is best to give the adversarial parties a chance to to weigh in on these particular issues. And certainly, courts don't let parties, for example, control things like standing, like jurisdictional issues, right? You can't, the parties just can't agree, hey, you've got standing, or things like that might deprive the court of jurisdiction. So, yes, it is the party's case to litigate, but I think there are instances where it is okay for courts to do what the D.C. Circuit did here. Although we'll see what happens on Bonk if the case goes there.
Yeah, I'm of two minds about it. I do. I mean, substantively, I like the idea of getting rid of federal regulations, right? So that's my bias, and I'm sure both of yours. But so many cases we've had at IJ, the judges come up with something usually because they don't want to judicially engage with the constitutional issue, and so they come up with something, whether it's cases that I think we talked about in Short Circuit a couple years ago, and the Ninth Circuit, where I think our colleagues Sam and Diana had, where they came up with a younger abstention reason to get rid of the case that no one was asking for. It's sua sponte. And then recently in the Fifth Circuit, Jeff Redfern and his colleagues had the takings case there, SWAT takings, where police basically destroyed someone's woman's house, and had all this history in the decision that was never briefed. And so at a minimum, ask for supplemental briefing, right?
Yes.
At that point, like, we understand. And here, I think maybe the weird thing going on here, curious, Deanna, your thoughts, and maybe go into where this case might go from here on Bonk or Supreme Court, is because both sides were on the same side of this.
Right.
They're kind of repeat players who like playing the CEQA game, right? Especially the government, that they're not going to ask for that. So unless you had like some really well prepared amicus come in, you're not going to get that briefing.
So it's yes, the both. I took a look at both of the en banc petitions. They both make a lot of the same arguments, which are we didn't present this, right. This isn't what we asked you to do, and this remedy isn't what we asked for either.
Right.
Right. And so Could we get a couple more judges in the room, right? Like, could we take another run at this? The last item on the docket as of taping was a request for the parties to reply to the en banc petitions. I think to see how it gets fleshed out. I think, Anthony, like you, I kind of expect en banc to get this one to get en banc. I also think that what might be going on here is, they are repeat players. They play by these rules all the time. They understand the rules. And I don't know if they like them. It's what they have to do, right? But everybody's got 30, 40 years of experience with it. I don't know how this issue gets teed up for review. But, if the court wanted this issue to be, they needed to raise it. Right, they were going to be the ones that had to bring this to the forefront and say, we have this ability to look at these things. It reads to us like that this is a violation of separation of powers, and now the issue is teed up, whether it's en banc or at the Supreme Court. We will get somebody to brief and adjudicate whether or not the CEQ regulations are things on which the agencies need to rely. I also think one of the things this case illustrates is we have the time part of the recent Supreme Court decisions, and a lot of it from the perspective of agency action, agency authorization. No deference, executive orders, like kind of limiting that. We also had a statute that was really clear that said, hey, you guys have to regulate this air travel, and you have to do it now. And the agencies did not do it for 20 years, right? They still haven't gotten it done. And so you have, like, almost on the one side, agency nullification of Congress, and on the other side, agencies acting without congressional approval. And so you have a case that doesn't really jump off the paper at you, regulating private air tours over national parks. You have a pretty decent snapshot of a lot of the issues that people are talking about today.
Well, we will see where this case goes, but I think it's definitely going somewhere. And if it doesn't go anywhere, I will say now, people who don't like secret rules, they can smell blood in the water. And so this issue is coming back.
The regulated community, whether it's the developers and project proponents or environmental groups or the agencies themselves, don't know what to do with this, right? Like this is because the rules by which they play and have been playing have just been scuttled. And so I think my guess is you're right. This case goes someplace because people don't know. No one knows what to do right now.
I bet you, like the day after, they woke up in the morning and said, "Oh no, we made our sequa disappear." That's a reference to Home Alone. Just in case.
Well, thanks. I have seen that, but didn't get that one.
It was a stretch.
Well, I'm going to stretch with our closing, and that's to thank both of you gentlemen, for joining us today. And ho ho ho, as was said in Die Hard and many other times. Now I have a machine gun, and I hope everyone has a wonderful holiday season. Is having a wonderful holiday season. Please join us again in the new year, and please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.